Right. Welcome, everybody. This is Michele Colo with EverFi. I'm a demand generation manager here, and I am in charge of running, among other things, the corporate compliance webinars. So chances are that if you are here on this call today, you've received an invite from me. And so thank you very much for heeding my call. And welcome to the webinar again. I just have a few housekeeping items I want to run quickly through before we start. So for those of you who might not be as familiar with the GoToWebinar platform, there's a question box on the right-hand side of your screen. Please do put your questions in there. This is a pretty short event. We try to keep it 30 minutes, so we may not have time to address all of your questions at the end, but by all means, do put them in there so we can get back to you even on an individual basis once the event is over. A full recording and a copy of the whole slide deck will be circulated at the end of this event, so you don't have to worry about receiving that because it will be mailed to you as a follow-up. And lastly, we have a quick quality survey at the end of the event that will just initiate once you close out. Of course, it's a non-mandatory survey, but we do value your feedback greatly. So if you could please just fill it in. It takes about 2 to 3 minutes. We'd really appreciate your feedback on today's topic. So I'd say those are the housekeeping items. And now, without further ado, I would start us off on today's topic. So there's been a recent insider trading case decided by the Supreme Court called Solomon versus the U.S. It's been all over the news, so you've most probably already heard about it. I guess it's fair to say that this event has left some of the commentators and observers a little bit surprised. So we decided to take a closer look into it and also go back and see how this kind of fitted within the overall Supreme Court case law. So presenting on this topic today is our very own Steve Tregus. You've probably already been on some of Steve's webinars in the past, or you have read him. He's also one of our blog authors. Steve earned his JD from John F. Kennedy University School of Law and BA from Sonoma State University. After a number of years in employment law private practice, he then joined EverFi, formerly Law Room, as a legal editor. And today he writes courses for us, monitors litigation, publishes legal updates, and great blog articles in the employment law and compliance domain field. You can check some of Steve's article at blog.lawroom.com. Welcome, Steve, and thanks for being with us today.
Thank you, Michele. Happy to do it.
Great. So why don't you start us off? I know you've been researching this topic very thoroughly, so looking forward for you to let our audience know what you found.
Sure, let's get going. This, as you can see here by the title, presentation is on the latest Supreme Court rulings on insider tradings, which I subtitled, Why the Complicated Case of a Grocer Taking a Gift and Going to Prison Matters, and that's what we're going to talk about. So by way of introduction, the Supreme Court of the U.S. recently decided a case called Solomon v. U.S. This was a major insider trading case against a grocer who cashed in on tips of inside information, but who wound up holding the bag when members of his extended family of tippers pleaded out. So first of all, I'd like to do a little bit of background, some vocabulary, to make sure we're all on the same page about what insider trading and tipping are all about. So insider trading is trading securities while in possession of inside information. Inside information, in turn, is material non-public information that's illegal to disclose or trade on. A fiduciary duty, which comes up a lot in this case, in the insider trading context, is a duty not to disclose or trade on inside information. Also, tipping inside information is a very important concept in this case. Just as it's illegal to trade on inside information, it's also illegal to tip others or to trade while in possession of that information. A tipper is someone who illegally tips inside information, and a tippee is someone who receives a tip of inside information and trades on it. Solomon v. U.S., as Michele observed, requires us to look at several other cases that have been very relevant to its formation. So those include not only the U.S. Supreme Court case, Salmon v. U.S., but U.S. v. Salmon, which is what the case was called when it was at the Ninth Circuit Court of Appeals below. We're also going to look at U.S. v. Newman, which was interpreted by Salmon. That was a Second Circuit case there in New York that was sent up for review to the Supreme Court, but the Supreme Court denied review, which had implications for us. And finally, a very important case that was a very precedential case from 1983 called Dirks v. SEC, another Supreme Court case. So the main event, Salmon v. U.S. So first of all, let's start with an overview. Very recently, on December 6, 2016, the Supreme Court upheld a grocer's conviction for insider trading based on tips from a member of his extended family. That was Salmon v. U.S. Now, what's an interesting and significant fact is that the person who was the main character, as it were, in this was not some Wall Street high flyer. He was a grocer from Chicago, which makes the case a bit surprising in and of itself. So the grocer's name was Bassam Salman, and he had argued that the person who tipped did not gain financially, and because of this, Salman should not be convicted. Let's explain why in the upcoming slides. But first of all, the holding was that Salman's close relationship with the tipper meant that there was no need to prove financial gain, so his argument ultimately fell apart. But why is that important? Let's take a look at this. First of all, based on the facts. So the first person involved in this, the first character, was a Citigroup investment banker. And that person had some inside information that he tipped to his older brother. The older brother, in turn, tipped his sister-in-law's brother, who was Salman. And Salman then traded on the tip and made a lot of money. So the DOJ got wind of that. The DOJ is the Department of Justice. They got wind of it, and they brought insider trading and tipping charges against all three of them. The two brothers plea bargained, but they fingered Salman, and Salman fought. But he was convicted, alas, of insider trading. Salman faced about $730,000 in fines and restitution and 3 years in prison. So he appealed to the U.S. Court of Appeals for the Ninth Circuit. Meanwhile, back in what's called the Mother of Securities Courts, the Second Circuit, decided that a tipper must gain financially for a tippee to be liable. That was the case U.S. v. Newman that I alluded to earlier. Salman got wind of this, and he argued that Newman applied to him because there had been no financial gain by the tipper, in this case, the Citigroup investment banker. Ninth Circuit, however, disagreed, and they upheld Salman's criminal conviction. Salman, of course, didn't rest there, or else we wouldn't be talking about this. He petitioned the U.S. Supreme Court for cert, which means judicial review. And in the meantime, in Newman, the government requested judicial review or cert to Newman, but the Supreme Court denied that. Now, why are these related? Because the Supreme Court's denial of cert to Newman looked good for Salman, and that's what we're going to explore next. Specifically, Newman looked good for Salman because the denial of cert to Newman seemed to mean the Supreme Court agreed with the holding in that case. The tippies were not guilty of insider trading when the tippies were not close to the tippers. In that case, they didn't even know them. And the tippers did not gain financially. So this applies here, but the Salman's defense actually wanted to focus on the second of the 2 points that were part of the ruling in Newman. So as you can see, it's emphasized that tippers did not gain financially. They thought that was very important for their case because that tracked the facts of Solomon's case. In fact, it looked good, but they wanted to de-emphasize the first part because in Solomon's case, even though the tippers were close to the tippies were close to the tippers and knew them well, I mean, they were extended family. Still, the tippers did not gain financially, and that was the whole point of the defense. The Supreme Court, unfortunately for Solomon, went the other way. The Supreme Court disagreed with Newman for saying that the tipper must gain financially to prove the tippy was liable. Instead, the Supreme Court relied on an old precedent that says that tippies who participate in the tipper's breach of a fiduciary duty for a personal gain is liable, and that was that case I told you about at the beginning from 1983 called Dirks v. SEC, another Supreme Court case. So the Supreme Court really analyzed this not so much on the principle of financial gain, but they rather looked at what is personal gain. And the Supreme Court held in Solomon that personal gain can include a gift of a tip to a close trading relative or a friend. So to a close trading relative, which means someone who is close family or a friend. And I quote, "Giving a gift of trading information is the same thing as trading by the tipper followed by a gift of the proceeds," according to Samuel Alito of the U.S. Supreme Court. So Solomon's conviction was upheld because he knew that the inside info originated from a breach of the tipper's fiduciary duty. He participated in the tipper's breach of fiduciary duty by trading on inside information. And the tipper, that is the brother from Citigroup, gained personally by his gift to a trading relative. Now, that may seem a little bit opaque at first.
Right, Steve, if I can jump in.
Oh, sure.
I think this is probably one of the most interesting part of this ruling. So I think to probably somebody on the line, and definitely to me at first, it sort of seems like the court is following a circularity argument here, where they're saying you're gifting information, and that's a gift because it's a gift. So can you maybe articulate a little bit more on this point? Because I'm sure.
Right, I see that can sound a little bit confusing at first. So I think it's kind of helpful to look at an example and make it a little bit more concrete. So let's say that you and I, Michele, are brothers. We're long lost brothers, but we are brothers. And so you work for some New York firm, some Wall Street firm, and you get lots of inside information. Now, you're not supposed to disclose it, you're not supposed to trade on it, and you know that. So you can, but maybe you're not exactly an ethical person. Unlike the real Michele, you're going to be this alternative universe Michele, and you're going to say, I could make a lot of money on this. If you did illegally trade on that information, then clearly, you committed a crime. But let's say that you say, well, you know what? I don't really need the money. I'm doing fine. But Steve, my brother, I've been seeing him drive this beat-up old car, and he's always wanted a Beamer. Why don't I see if I can get him one? But instead of just buying him a Beamer, why don't I tell him about this inside information? And so you tell me all the information. I trade on it, and yeah, I got 2 Beamers, it turns out, because I really profited off that information.
So it's kind of like I'm saying, hey, Steve, I can't do this, but you should.
Right. And just to emphasize the point, at oral argument of this case, Justice Breyer said that, I'm not sure if I can remember the exact quote or if I have it here in my notes. My computer's off, so I'm going to have to do it by memory, which is that he said something to the effect that helping family members like helping yourself. So that's how the court was thinking on this.
Oh, that's it. That definitely clarifies what the thought process was there.
Good. I'm glad that's helpful. And I appreciate the question because I don't want to get into legal jargon. I want to make sure this is very clear. I mean, this is the point of the webinar here. Sure. So let's do a little summary of what Solomon was all about. First of all, tipping means that the tipper gains a personal benefit for disclosing inside information in breach of a fiduciary duty. Secondly, a personal benefit includes a gift of inside information to close family or friends. Third, family or friends participate in the crime by trading based on the gift, knowing the tipper's breach of duty, just like in the example we talked about with Michaelia and I. And finally, when that happens, both the tipper and the tippee are culpable. So next I'm going to talk about why it matters. That includes looking at the legal consequences first. And in that regard, a prosecutor, specifically the Securities and Exchange Commission, that is the SEC and the Department of Justice, or DOJ, now can prosecute gifts of inside information even if there was no monetary gain. The court also was very clear in the case itself, in the written opinion, that they were very narrowly focused on the facts before them, and they did not want to entertain hypotheticals. So the court did not specifically say whether the rule applies to tippees other than close family and friends who know that the tipper breached the duty. So that leaves us some questions. How close do tippees and tippers need to be for liability to accrue? Could a gift to a stranger be included? Well, at first it doesn't look like that, but since the Supreme Court said we're not entertaining hypotheticals, what would you do if you were a prosecutor and, that was your mission in life, is to prosecute violations of the law as you saw them? Well, maybe you'd want to stretch it a little bit. The Supreme Court didn't say we can't prosecute these, so maybe you'd want to do it. We'll have to see what the SEC and the DOJ actually do to find out how they're going to interpret this ruling. So I guess we have a poll question here.
Yeah. And with that, so we would like to ask the audience, we have a lot of qualified people on the line today. We've got general counsels, we've got associate counsels, and compliance officers. So we would like to know, how surprised were you with the outcome of the Solomon ruling? So I'm going to open up the poll and allow you to vote, and would love if you could just give us your feedback on this. So the question again is, are you surprised with the outcome of the Solomon ruling? And you can select whether you were very surprised, surprised, neutral, not so surprised, or not surprised at all. We're going to give you just a few seconds there to put your vote in, and then we're going to display the results of the poll so all of you can see how people have voted today on this topic. Just going to give it another couple of seconds. If you haven't voted yet, if you would like, we're going to close the poll in just a few. All right. So it's very interesting, Steve.
Yeah, that's kind of what I expected, that there would be quite a few people surprised. It's not quite a majority, but about half of the people were surprised. And so, right, and I think that just underscores the value of explaining it to that contingent of people who were surprised by this ruling.
Absolutely, and it's definitely showing how divisive it is, right? Because we have about 50 people who are surprised, and then another 50 that are basically either not surprised or not surprised at all.
Right, but not so surprised implies that there's some surprise, and that's a 25% number there. So it looks like we've got the right audience here. It's like we're hopefully what we're saying is going to be helpful.
Absolutely. So I'm going to just put down the poll, and we can resume the presentation real quick.
Okay. So with that, let's take a look at the practical consequences. We just looked at the legal consequences before the poll. So practical consequences involve the fact that insider trading hurts investors and markets, and there's a conflict of interest even if the behavior is not clearly illegal. So by that, I'm talking about risky behavior that may be on the edge, or is in the gray area. And so as people who've been around for a while know, if you're constantly pushing that line, then pretty soon somebody's going to start going over the line, because that's just how corporate culture works. That's just how human behavior works. If you keep getting away with something that you're not sure that you should be getting away with, sooner or later you're going to just say, and you're going to go right across that border. So that's why it's so essential for people to know the red flags and to train everyone who works with you and works for you and may at all be engaging in or have even the potentiality of engaging in risky behavior to know not to do so. And that brings me to the second point, which is that effective compliance programs are essential in the face of legal uncertainty. And the twists and turns of this case, including what happened in Newman, including the various interpretations, really show how important it is to have an effective compliance program. So that brings us to compliance considerations. So for one, a lot of us read the headlines every day and try to keep up on things. That's really important. But of course, it's not enough, because you're just reading summaries. You're not getting the real picture, and also you're not seeing how it applies on the ground to real people in these situations. And a related point, general knowledge or even general policy statements, don't do this, don't engage in insider trading, whatnot. That's really crucial. You've got to do that. But it's not enough, again, if you don't apply it to specific situations, and if your employees don't understand how these policies and compliance programs affect their day-to-day lives. And then the last point here is that it's hard to predict how the law will apply to particular situations. I mean, we just saw that with how the court's rejection of cert Newman seemed to look really good for Solomon, but it turned out that as it played out, it didn't look so good for him. And that was a real-life situation where it was really hard to apply the law without some real concrete understanding of boots on the ground kind of understanding. So it looks like we're leading to another poll question.
Yep. So this is kind of a little more interactive part of the webinar. We thought many of you would have some particular ideas and concerns about the impact and effects of this decision. So one of the things that we've thought about is, if some of you are concerned about the potentially expansive interpretation that, as Steve was starting to say earlier, the SEC and the Department of Justice may be giving to Solomon in the future, which may lead to a sort of maybe a spike in prosecutions. So, you do this every day, you're out there in the field, you probably have a better sense than we do. So we'd like to know from you, are you concerned about the SEC and the Department of Justice interpreting Solomon in the future? You can either be very concerned, neutral, not so concerned, or not concerned at all. Many of you are voting. Thank you for that. I'm going to give it another couple of seconds, maybe 30 seconds for you to keep voting. And then we're going to close it out. All right, I think that's it. I'm going to close out and display the results on this one. So there is a general neutrality, I'd say, Steve.
But yeah, that's true. But I think that being neutral is probably a lot more healthy than, and since we have zero saying this, I'm going to just say it right out, a lot more healthy than being not so concerned and not concerned at all, because that at least means if you're neutral, at least it means you're kind of open and looking around, and maybe it means you're of a calm mind. I also think that being concerned or very concerned is also quite reasonable in light of, especially that more than 50% of you were surprised, or at least a little bit surprised, like not so surprised, but still a little bit surprised. So considering that these things do kind of creep up on one and make a difference, it's important to, at the very least, keep your eyes open and and be aware of.
All right, let me close this out and let you resume with the presentation.
Sure, let's go ahead and move on. And speaking of being surprised, I was in the camp that was a bit surprised. And I'll show you how that kind of played out. I was creating an insider trading course, which came out in 2016, very recently, and so it's still a very new course. But in researching that, I looked at our older insider trading course that was maybe, it may have been like something like 10 years old or something like that, and that course had been rolled out on a very limited basis for a few clients, but it's always good to see what we've already done so you don't reinvent the wheel. And so when I looked at that, I saw that in that course there was no interactive scenario involving tipping and personal gain, not to the extent that we needed to, I felt. And this was, as I looked at this, it was just after Newman had come down the pike and the Supreme Court had denied cert to it. So it seemed clear that we needed such an interaction. So I made sure to add an interactive scenario involving monetary gain by a tipper. So that gave, for anyone who doesn't know what an interactive scenario is, as it sounds like it gives the learner some practice role playing and making a decision about what's compliant. And so I made sure that was added to the course. Later on, there was Solomon came down after the course came out, and so we did have a scenario involving monetary gain by a tipper, but we still had fully shown how personal gain or personal benefit affects real world interactions involving insider trading in the course. So I got together with an instructional writer, which is our usual procedure, and I explained to them the case of Solomon and told them that, hey, I'd like you to please write up an interactive scenario that reflects Solomon but changes the facts enough so that it's still the same case, but it can apply to any worker. And so we put that together and included the Solomon case in as an optional reading. And so now we have also an interactive scenario involving gifting by a tipper in which there was no monetary gain, so that learners will make sure to understand and role play that kind of scenario. So that leads us to compliance programs in general, and compliance problems. So as it says here, Solomon and the related cases that I talked about illustrate nuanced situations where the law would apply differently depending on the facts. And also a compliance program that does not effectively communicate this, or that fails to give employees practical examples, or better yet, practice role-playing, dealing with gray areas, we feel that just does everyone a disservice. So that's why we feel so strongly about this and work so hard on it. As far as compliance solutions, that's what we're looking for in the end, and we feel that interactive training, which is vetted and put together by legal and instructional experts, helps employees to negotiate nuanced situations that they may encounter every day. And so this concludes the webinar, except for we may have a couple of wrapping up things in the poll question. But before we do that, I'd like to point out that we have additional resources for you to read. I put out a blog that talks about Solomon. That's the first one, Tips as Gifts, and also before Solomon came out, we discussed the implications of Newman and the denial of cert to that, and that's the second one there called K-Mono. Okay, and so that leads us to, as I said, our poll question, our third poll question and final poll question.
Yeah, and this is just to bring it all together. We still have a lot of you on, so we're going to launch the poll in just a second. I wanted to wrap it up. We've come at about the end of the webinar now, but just as Steve outlined, I think very well, there's many nuances to behaviors that can be considered or not as insider trading. And so however you're doing this, you want to make sure that you are actually pulling from real life scenarios and allowing your workforce, your employees, to recognize and understand behavioral patterns that are okay, and also the ones that are actually red flags, even
Absolutely.
if they're not in the legal domain just yet. So this is for us, we're just curious to see, and you're probably curious to know also from the rest of the audience out there, if you feel that your current insider trading effectively addresses this risk. So you can start applying in just a second, and we would like to know from you if you strongly agree, so you think that your current training effectively addresses, you just agree, disagree, strongly disagree, or it might be that you're not even training in this area at the moment. So if you could put in your votes, we'd like to know what you're seeing out there, how you're sort of like planning and tackling these issues. Going to give it just a couple of seconds. Then we're going to close out the poll, just a recap of the housekeeping items, and then the webinar will be over. So we're just about on time here. So people are still voting, so I'm hesitant to close the poll just yet. I'm going to give another maybe 10 seconds. And here it is. So there's a good component of you out there that think that you have a training and you agree that it does effectively address the risk of insider trading, which is great.
That is good.
And on the other hand, there's some of you that are not training in this area at the moment, which is also, it's okay, but you might want to.
You may be opening up yourself to some legal risks.
Yes, absolutely. So these were the results. I think we might have just a couple of slides with context that we might want to flash.
Sure.
But
sure, do we have time for questions? No?
We had a couple of questions coming in, but I think we're done with the time today, so I don't want to keep anybody from their busy days.
Okay. If they're legal questions, or compliance questions, I'll get back to you later then. Sorry about that.
Absolutely. It was planned for. So these are the contacts if you'd like to reach out to us. Alternatively, if you are curious to see how we are doing this as a company, EverFi, we obviously do offer a insider trading training course for compliance purposes. If you'd like to review it, you can just type in demo at the right-hand side of your screen, and we'll make sure that one of our training experts reaches out and shows you how our courseware looks like and how our training strategies on these topics have been designed by Steve's team and by our instructional design team. So again, if you just like to type in demo on the right-hand side, will signal to us that you want to be contacted. Otherwise, you can obviously, these are my contacts flashing on the screen right now. I'm going to, soon I'm going to close down the audio, but I'm going to leave them just for a couple of seconds for you to take note if you need to. The webinar is now over. Quick rundown of the few housekeeping items we mentioned at the beginning. Everybody will get a recording of this event, and everybody will get a copy of the slide deck. It will be sent to you in a follow-up email, and there will also be a short quality survey when you close this out, where we ask you to let us know what you thought of the content, what you thought of the event. If you could be as kind as to fill that in, it probably takes 2 to 3 minutes. We will take in great account your feedback, and we will also use it to help us inspire our design of future events. So thanks for being with us today. Thanks, Steve, for the great presentation.
Thank you. This was it was really enjoyable.
Thank you. It was the same for us, and I hope for our attendees. But we had a pretty consistent following throughout the end, so I'm pretty sure it was. And thank you, everybody. Stay tuned because we'll be running more of these in the future. So